Our guest today is Russell, a director at Quinn Scattini Lawyers, team leader of the Wills and Estates team, and accredited specialist in Wills and Estates. Thank you for joining us, Russell.
Thank you, Dimitri. Pleasure.
When you need big firm expertise local to you, get together with Quinn and Scattini Lawyers in Brisbane, Beenleigh, Caboolture, Ipswich, Cleveland, the Gold Coast and Jimboomba. See qslaw.com.au.
So we're going to be discussing today the topic of wills and estates disputes. We'll probably get right to it. The first question that I have for you, Russell, is suppose that someone leaves a large gift to a charity in their will. Are they able to contest this if they feel that they don't have a greater share in it, or what would they do in such a scenario?
Well, this is precisely the situation that led to a change in the law over 100 years ago. New Zealand led the world in enacting legislation to address this type of problem. There are certain categories of people who can claim a greater share of an estate. There are limited categories. I'll only talk about what the situation is in Queensland.
Yes. Other
states of Australia and other countries have slightly different rules, but it's all very similar to the law in Queensland, which is that if a person who's made a will, or has failed to make a will for that matter, has left their estate so that someone who they should provide for has not received adequate maintenance and support under their will, and that's a key phrase, adequate maintenance and support, then that person can apply to the court for an order for further provision to be made out of the estate. This is commonly called a family provision application, or as lawyers like to abbreviate it, an FPA. So there are, as I mentioned, only certain categories of people who can claim further provision from an estate, and they are the spouse of the deceased, a child of the deceased, and certain limited categories of a dependent of the deceased.
So you touch on spouses. So what would happen in a situation where a person marries for a second time, where they leave everything to their second spouse and their own children are left out of a will? What can be done?
Well, I've seen this situation arise many times, and it's not really something very odd or uncommon. You can imagine that when someone does marry a second time, they would expect to leave their entire estate to their second spouse. And the problem then is that the children of the first marriage receive nothing from the estate of that parent, and what can happen further down the track is that that second spouse, who is the step-parent of these children, then leaves the estate entirely to their own children. And so their stepchildren then have stood by while, let's say, Dad left his estate to his second wife, and then she leaves everything to her own children, and they miss out. Mm-hmm. So those stepchildren of the deceased can claim further provision from the estate of the second spouse of their natural parent.
So with further provision, does that include a de facto spouse? And what if there is a dispute whether the person is actually the de facto spouse?
Well, that's right. A spouse includes a de facto spouse, and there often are disputes about whether a person was a de facto spouse. You have a situation where a de facto relationship simply depends upon all the facts being examined to determine whether or not there was a de facto relationship. The law doesn't have a fixed set of criteria to determine whether a de facto relationship exists. It has a floating set of criteria, and just because you tick one of the boxes and not others doesn't mean that you will or won't be determined by the court to be a de facto spouse. We often see that. There are some situations where, for example, a person may have been living in the same house as the deceased person,
yes,
may have in the past had a de facto relationship with them, but when the person passes away, their children claim that the de facto relationship had ended and they were just living in the house out of convenience, but had actually ended their de facto relationship. One of the factors that we often see also is that people look at whether Centrelink benefits were being claimed on a single or couple basis, but even that won't be determinative of whether or not there was a de facto relationship.
We sometimes hear the term elder abuse, which seems to include situations such as an adult child persuading an elderly parent to transfer property to that child. Can anything be done in such a situation?
Yes, that's right. And we've had some cases like this that have been decided in the Supreme Court in favour of our clients. Lawyers like to use a bit of Latin now and then, and one of the Latin phrases we use is inter vivos, which simply means between living people. So although we're talking about wills and estates, sometimes we deal with transfers of property that have happened inter vivos, between living people, and they only get contested after the person has passed away. So for example, an adult son persuades and coerces an elderly parent to transfer a house property to that adult son, and the elderly parent has been the subject of undue influence, or what we call unconscionable conduct, but the elderly parent doesn't do anything about that while they're alive, and then they pass away. It's then possible for the other children of the deceased to challenge that transaction, and the court will, in an appropriate case, reverse that transfer so that the property then lands in the estate of the deceased.
What about a situation where we say a parent has given a large gift to one of their children, their adult children, and that parent dies and leaves the remaining estate in equal share to all the children, including that child that they gave a large portion to whilst they're alive? Can anything be done in such a situation?
Yes, so this addresses the situation where there's no question of undue influence or unconscionable conduct. It's a fair and reasonable gift by usually a parent to an adult child, but it can deprive the estate of a significant portion of what would have been in the estate. The court, on an application for further provision, will take that into account, and so where a person has already received substantial provision from their parent while they were alive,
yes,
then the court will endeavour to ensure that even that taking that into account, the children receive adequate provision from the estate. So if the will then leaves what's left in the estate in equal shares to the children of the deceased, but one of those children has a greater need for provision, then the court can alter that and take a larger share of the estate and give it to the child who has the greater need.
In the scenario where an adult child of the deceased person challenges the gifts under the will the court simply order that the estate goes in equal shares to all the children, or what would happen there?
Well, that does follow on from what I was saying, that there's no presumption of equality, and this applies whether or not there was any inter vivos transfer of property. There's simply no presumption of equality. The court will look most importantly at need. That is the crucial element of a claim for further provision from the estate. So suppose you have a parent who dies and leaves an estate of, say, $500,000, and they have 2 or 3 children. One of those children is very well off, and the other 2 are in receipt of Centrelink benefits, disability pensions, for example, and have no assets to speak of. You might think that the parent has done the right and sensible thing by simply leaving their estate in equal shares to their 3 children, but the court can take a very different view and can take a larger portion of the estate and give it to those children who have the greater need.
So following on from that, what deadlines apply for claiming further provision from an estate if you have further need, or greater need rather?
Well, that's very important. The first deadline that a person needs to bear in mind is 6 months after the date of death. Within that 6-month period, a person who intends to claim further provision from the estate must give written notice to the executor or administrator of the estate, informing them that they do intend to claim further provision from the estate. Then they've got another 3 months, so it's 9 months after the date of death in total, within which to commence court action claiming further provision from the estate. Those are the general rules about the deadline dates. In certain scenarios, there can be some adjustment to those dates.
If a court makes an order that affects, well, my share, if it was for me, in an estate, or you're not aware of the person having passed away and any proceedings having occurred, is there anything that can be done about those proceedings to ensure that you get some portion of the estate?
Well, the good news is that the court has rules in place to ensure that all interested parties must be notified of the court action before it will make an order for further provision from the estate. That's an essential element of every application for further provision, that all parties who may have an interest in the estate have to be notified that the court application has been made. And then if they wish, they can join in the court proceeding and put forward their views on the application.
Fantastic. No, thank you very much for your insights, Russell. It's truly appreciated. Thank you for joining us. If you have a greater need, or a family member or loved one has passed away and you're concerned about your rights, feel free to call us on 1800 999 529. It is important to obtain prompt legal advice in such a scenario, or you can visit our website www.qslaw.com.au.
Thanks, Dimitri.